Good morning, everyone.
Okay.
Kathy, you have any introductory information to provide for them?
I do. We're so pleased to have so many of you joining us today for Mathematics of Zero-Sum Negotiations Through the Looking Glass. If you'd like to minimize the GoToWebinar dashboard, just click the orange arrow to the left of the control panel. All attendees are muted for the presentation, but if you have a question you'd like to ask, please go to the questions drop-down on your control panel. We're collecting all the questions to be answered after the conclusion of today's webinar. We thank the University of Florida Levin College of Law Institute for Dispute Resolution for co-sponsoring our CLE webinar series. Today's presenter, Howard R. Marsee, was a board-certified civil trial lawyer for 20 years, until 2003. Since 1996, he has served thousands of hours as a mediator, arbitrator, and special master. He is certified by the Florida Supreme Court to receive circuit civil mediation appointments. He's also certified by the U.S. District Court for the Middle District of Florida to receive mediation appointments in cases pending before that court. And he is approved by the Florida 5th District Court of Appeal as an appellate mediator. He is a former member of the Florida Bar's Standing Committee on Professionalism. And now I'm going to turn it over to Howard. Let me give you the keyboard and mouse, Howard.
Thank you. Good morning, ladies and gentlemen. Today, we are going to try to pack a lot of information into 1 hour and 10 minutes. I'm going to try to share with you in that tight allotment of time some negotiation tools and concepts that I have learned through thousands of hours of study, negotiation, and service as a mediator. I warn you in advance, this is a working webinar. I strongly suggest you have a pencil, some paper, and a calculator in front of you. As we get deeper into the subject today, you're probably going to need those if you're going to make meaningful sense of some of the subject matter. Because of the limited time, we're not going to be able to take questions at the end, but I'm going to give you my email. Actually, it shows up on the screen right now. Feel free to send me any questions after the webinar. I'll be happy to try to answer any questions for you. We've already received some pre-webinar questions, and I'll try to answer those as we go through the material. We're talking today about several subjects, and so that you'll understand the system, we're going to begin with the concepts that are perhaps more basic and easier to grasp, and then we're moving to the ones that are going to be a little more difficult. We're going to start with anchoring, then we're going to go to the concept of crossing the zero line, then we're going to talk about numbers as semaphore, and then we're going to talk about arithmetic breakpoints, break lights, and then we'll probably spend most of the time today on the subject of brackets. We could spend literally hours. There are complete courses devoted to bracketing in negotiations. I'll hit the highlights, but I'll try to demystify them to the extent that I can. Then we may talk a bit about risk analysis and the end game. What you see on the screen now is, of course, a piece of artwork from Alice in Wonderland. Those of you who are familiar with Lewis Carroll know that he wrote 2 books. The first was Alice in Wonderland. The second was Through the Looking Glass. And in each of those, Alice, first she goes down a rabbit hole in Alice in Wonderland, and in the second she goes through the looking glass. But in both cases, she finds herself in worlds that are not quite what they seem. Well, that's what numbers can do for us in negotiation. They can be very helpful or they can be very dangerous, depending upon the facility with which we use them. A little quote says, Alice could not help her lips curling into a smile as she began. Do you know, I always thought unicorns were fabulous monsters too. I never saw one alive before. Well, now that we have seen each other, said the unicorn, if you'll believe in me, I'll believe in you. Is that a bargain? That concept is central to using numbers to reach a favorable result in negotiation, because what numbers do is they can overcome distrust in each of the parties. They can help to overcome distrust in the negotiation process. They can provide some basis for believing that you're making progress at all. In short, they can avoid bogging down the process and eliminate some of the mutual discouragement that goes from proceeding in baby steps. So to that extent, they're very useful. But if you don't know how to use them, or if you use them ineptly, they can also sabotage the process, and you can end up with a result that you really don't want. And hopefully when we get into brackets today, I'll show you how one of the attorneys at least made some serious mistakes. The numbers become a means of analyzing the risk, of sending signals to one another, guideposts, waypoints, cryptograms. Someone in a pre-web questionnaire asked me, what are cryptograms? Well, the best way to think of cryptograms are sort of an occult code or system of signaling. And that's what we do so often in negotiation. We're not really sending direct signals to one another. We're actually talking in code. And that's where the numbers come in and become very helpful. If misused, they can, of course, lead us down the rabbit hole. And that, of course, is what this illustrates: a misunderstanding or misreading of the numbers or misuse of the numbers can sabotage a negotiation. So today I'm going to share some key concepts with you that I hope you will find helpful in your negotiation. We're going to approach mathematics from the negotiator's point of view and see what we can learn. I am not approaching it today from the mediator's point of view, although obviously we will touch upon that at some points in the process. First thing I want to concept is what are zero-sum negotiations? That was one question we had in the pre-webinar questionnaire. Zero-sum negotiations are really negotiations in which the paramount issue is money. Purchase of a house and sale, purchase and sale of a house or of a car, where one party wants as high a number as possible, the other party wants as low a number as possible, with each party trying to pull the deal toward their end of the spectrum. Now, I suspect many of you today may be family mediators, and I realize that this webinar may not have as much value to you as it does to someone else, but somehow I ended up need to go back one. Here we go. But still, there are some concepts here that I think or some principles that I think you'll find useful. But zero-sum negotiations are really those where you're negotiating essentially between 0 and X dollars. Now, that's not to say that that's the only thing that you're negotiating. Even zero-sum negotiations usually involve some collateral or incidental issues. For instance, if we reach a number, how about confidentiality? How about an agreement of non-disparagement? How about a covenant not to compete? If we lower our number, will you give us a covenant not to compete? Maybe we can reach a number by dividing up sales territories that are in dispute. So all of those are things that enter into zero-sum negotiations. Anchoring. This is the next concept. It's a psychological phenomenon. We are, as human beings, unduly influenced by the initial figure we encounter. That's why car stickers are so important. Everyone who is savvy in car buying negotiations know that you never pay the car sticker. Well, the car sticker is there as an anchor. The dealer wants to influence what you see as the value of the car so that your numbers will tilt toward that anchor. That's why you see an interesting thing happening now on television. People have gotten very smart when it comes to ignoring car stickers. So now on television, you see the TV ads that say the number you see on the sticker is the number you pay. Of course, leading you to believe that they've already priced the vehicle at rock bottom. For those who may be inclined to be gullible, don't fall for that. Any negotiator will tell you that everything is negotiable. And when you see a sticker on a car, what they're doing, of course, is throwing out that anchor. It's a reference point that anchors our expectation about an item's or a claim's value. In fact, studies show, there's some interesting studies out there, that negotiation outcomes often correlate to the first offer. An interesting experiment, I'm blocking right now, it was a university experiment, but there was a mock jury experiment. The plaintiff's attorney, in his closing remarks in a mock jury trial, suggested a verdict between $15 million and $50 million. The verdicts that came in averaged $15 million. In another scenario, the plaintiff's attorney suggested a verdict between $50 million and $150 million. The mean verdict that came in was $50 million. So you can see the powerful influence that anchoring has. Give you another example. You can just do this little experiment for yourself. If I were asked you to guess the weight of the Empire State Building to the nearest 100 metric tons, you would give me an answer. But if I ask you to estimate the weight of the Empire State Building to the nearest 10,000 metric tons, I suggest to you that your answer is going to be quite different. So anchoring is something that we need to be aware of. And one thing that's important for you to know in your negotiations, whether it's mediation or otherwise, is that a party with limited information is going to be disproportionately influenced by the other's anchor. There's a concept called heuristic. Heuristics are a cognitive shortcut employed in thinking to devalue information that can only be processed with difficulty. In short, we tend as human beings to make decisions on the basis of readily accessible information, and we tend to ignore information that we have to work to process. So it becomes very important for you Anchoring may be the most important thing you do in a negotiation. Where you set your anchor and where the opposing party sets their anchor is going to determine in large part the outcome at the end of the day. So it becomes important to you in evaluating where to set your anchor to look at the relative degrees of information available to you and the other party. The less information the other party has, the more susceptible they're going to be to your anchor. But in setting your anchor, remember one guiding principle. It needs to be a number that you can sell at the end of the day. What number can I sell as a starting number? What makes sense? And again, it's got to be a number that you can justify, but in setting it, you really need to follow what I call the poker algorithm for you who may be poker players. Think long and hard when you enter a negotiation. How much do you know about your case? How much do you know about your hand? How many of the facts are on your side? How much of the law favors your position? How much can you deduce about the weaknesses of the other opponent's case? What do you think your opponent thinks you are holding? All these things are essential to setting the right anchor point. There is a predictability trap in anchoring. For those of you who do plaintiff's work, you're very vulnerable to this. Some plaintiffs' attorneys are notorious and develop a reputation for asking twice what they want at the end of the day, 3 times what they want, or 4 times what they want. Defense lawyers and insurance claims people are very savvy. They learn what your reputation is. And the anchor you throw out may point, and you may want to point to a number, and you can use that in your favor. But if you're always a twofer or a fourfer or a threefer, people are going to be able to predict where you're headed. Defendants are at a real disadvantage in setting an anchor. They can only start at 0 unless you're talking about a case with a counterclaim. But even defendants can always be guilty of starting at the same number, $10,000, $5,000, whatever it is. In the long term, I would suggest to you that if you are sloppy in setting your anchors, or if you are overly predictive in setting your anchors, you're going to lose credibility. Crossing the 0 line is another concept. By the way, you notice I'm moving fairly quickly now. I want to make sure we have plenty of time at the end for discussion of bracketing. Crossing the 0 line is something that happens in where you've got claim and counterclaim. And that calls for special attention to the anchor point, particularly if you are the party who may end up paying the money at the end of the day. One thing that experienced mediator learns, where you've got a claim and counterclaim, plaintiff wants $100,000, defendant wants $50,000 on their counterclaim. Usually the first party to offer a washout is the party who ends up paying. That is, well, we'll just walk away if you'll walk away. So you should know at the outset if you're going to finally be the payer. And you ought to know that based on your case. But even if you know, let's say you're the defendant and you have a counterclaim, and you know between you and your client that at the end of the day you're going to end up paying the plaintiff something, you still can influence the end of the day outcome by setting your anchor favorably. you know, if you set and too low an anchor, then it doesn't create enough risk for the plaintiff to come down off their number. So even if you know you're going to be paying and you're a counterclaimant, don't be sloppy with your anchor. Your anchor can still save you money at the end of the day. Next concept is numbers of semaphore. For those of you who may be former sailors, you know what semaphore is. Those are the flags used for the visual communication among between vessels. Your numbers have to have meaning. You can't be a drunken sailor. Every number should have signal value. Every number should be carefully calculated by us to convey information. Because negotiations often result in a tug of war at midpoints, you need to know if the plaintiff is at 100,000 and you're the defendant and you're at 10,000, that whether the parties mean it or not, there's always lurking there a midpoint of $55,000. So you always need to be cognizant of that, and you need always to be careful in the numbers that you send. Don't be impatient. One of the principal rules of good negotiation is that if you make people spend time and effort in the negotiation process, you're apt to reach a better result at the end of the day. And I won't get into it now, but it gets into the sunk cost cognitive bias. But the more effort and time people invest, it's harder for them to walk away because they say to themselves, gosh, I've already got this much invested in it. So be patient. Remember, time and effort can be your ally. And always remember that midpoints can be deceptive. Arithmetic breakpoints. This is a fairly simple concept, but it's an important one. The larger the delta, that is the difference between your number and the other party's number, the more important round numbers become in terms of signal value. Let's say that the defendant has offered 79,000. Once he increases that number above 80,000, he has crossed a natural breakpoint. Round numbers tend to be breakpoint numbers. That is a signal to the plaintiff that the next potential breakpoint for the defendant is 85,000, and so on. The converse is also true. Plaintiff is at 74,000 and has been moving down in $5,000 increments. Suddenly begins to move in $1,000 increments. The reluctance to cross that $70,000 line becomes a signal that they may be reaching an end of negotiations. Now, this, of course, is a two-edged sword. It also can be used to game the game. You can deliberately skew your signals to make people think you're slowing down at a break point. But still, the concept is important. Always think that what is the next break point? And are they going to cross it? If they do cross it, what does that tell me? Brake lights. This is pretty simple. If you're driving down the highway and you slam on the brakes, you're going to get rear-ended. You really need to give a signal. I call it brake lights. You can do that by starting to move in diminishing reductions or increases, especially near the round numbers. We've talked about the breakpoints. For instance, if you're the defendant and you move 20,000, then you move to 30,000, then you move to 40, then to 50, and then you slam on the brakes, you've not really signaled to the plaintiff that you're running out of steam, and you risk damaging the negotiations. A better scenario would be 20, 30, 40, 41, 42, or 42, 41, 41, 5. Start applying the break lights. And again, all of these things, all these concepts are subject to being gamed, but you simply have to learn to recognize when you're being gamed. This, of course, is the famous scene with Alice and the Cheshire Cat. She asked, which road do I take? He said, where do you want to go? She said, I don't know. And he said, then it doesn't matter which road you take. Well, that's very true with signals. Remember, in a negotiation, we're constantly sending one another signals, and they're not always transparent. At best, they're opaque. So we're always trying to decode the other party's signal. But there's no excuse for not knowing where we're going with every number. We have got to know which road we're taking. Now let's talk about brackets. We could spend a day on brackets. I have been to seminars where full days were spent on brackets. I have read entire books on bracketing. So we're asking a lot to pack it in here, but I'm going to do my best. They're often misunderstood, and I see them frequently poorly used. Frequently, as a mediator, I will encounter attorneys that say to me, I don't like brackets. I don't think they do anything. Well, I can tell you as a mediator who spent thousands of hours in mediation that brackets are a marvelous tool if you know how to use them. They can get cases settled that would otherwise never be settled. And bracketing actually begins with the first demand and the first offer. Remember, we talked about anchoring. The first bracket in a negotiation is actually formed by the initial opposing anchors. Let's say the plaintiff's at $1 million and the defendant is at 0. Then you've got 2 anchors thrown out, and at that point you have a bracket of 0 to $1 million. So that is a bracket, technically speaking. The resulting midpoint between the 0 and the $1 million is 500,000 in our example. And that resulting midpoint is a fiction created largely in most negotiation by the plaintiff's opening anchor. And that's because the defendant can only start at 0. That's why the defendants often have a more difficult time in negotiations, because to get to a point where they think the case can be settled, or at least the goal that they have, requires them to get from the plaintiff larger moves than the defendant is making. So always remember that that first midpoint is a fiction. Now, that's not to discount the possibility that a plaintiff may be by the choice of his or her anchor deliberately telling you that's where I want to settle at the end of the day. Of course, you simply can't cave into that, obviously. Bracketing, I guess, can be best thought of it as negotiating toward a final single dollar settlement amount through the exchange of conditional proposals. Remember the example I gave you of the unicorn opening. If you'll believe in me, I'll believe in you. They are a way of instilling trust in the process and each other. Give you a few examples here, and here, if you've got a pencil and paper, it'll help you if you write these down. Plaintiff is at $1 million. Defendant is at 10,000. That gives you a midpoint of 505,000. Remember, that is a fiction. And let's say that then the defendant responds at $100,000. Now the plaintiff's at $1 million, defendant's at $100,000, and the midpoint is $550,000. You see what's happened to the defendant here. The midpoint's moving up and not down because it's so difficult for a defendant to move the midpoint down. But then look at this example. Plaintiff is at $1 million and the defendant has moved to 200,000. Now the midpoint is 600,000. Defendant has just shot him or herself in the foot because they have made retrograde movement in the midpoint. You've gone from a $550,000 midpoint in the previous example to a $600,000 midpoint. And we're going to discuss that further when we get into a detailed example later. So I guess one point I should make here, although it's probably a little early in the discussion, is that you never want to make a retrograde movement in a negotiation. And we'll show you how that works in the context of brackets in a moment. One question that was pre-webinar question was, when do you go to brackets? Well, usually you reach a point in a mediation where you're simply bogged down. And as a mediator, you can usually tell this because the plaintiff will say, the defendant's offer is ridiculous. It's insulting. And the defendant will say to you, plaintiff is still in the stratosphere. They don't have any intention of settling. Those are the type of cues you may be looking to determine whether it's time to go to anchoring. A survey was done by the Florida Academy of Civil Trial Mediators, and very experienced mediators were asked, when do they typically see people going to brackets during the course of a mediation? 45% said they see them as useful anytime in the process. 55% said they see them as more valuable late in the mediation. And 47% said that they suggested brackets only when standard negotiations stall or approach impasse. So, that's where a mediator can help you. Because they are taking the pulse in each room, they can often tell you when it may be a good time to go to brackets. Usually I find that brackets don't become useful until the parties have exchanged a few blows, where they've exchanged raw numbers and begun to see that they're not getting anywhere. And we'll see an example of that later. Here's some more theory and perspective. I think we've already discussed that arguably the midpoint between the starting anchors is the plaintiff's real anchor. We don't know that, but you have to consider that possibility. And parties begin to strive toward or away from the fictional midpoint as progressive offers and counter offers are made. At some point in time, both parties realize that those starting anchors, that starting bracket formed by the initial anchors, is unproductive. And that's when I think you have to consider going to negotiating a new bracket. I like to refer to this as rebracketing because I really believe that the initial anchors form a bracket. A mediator, of course, may suggest that the party go to brackets at some point in time in an effort to create a new, more realistic midpoint. Question is, who should initiate the new bracket? I will tell you from experience that most often it is the defendant who puts forth the first bracket. And the reason is because he or she had to start at 0. The midpoint of the new bracket, if it's carefully calculated by the defendant, becomes their first real anchor. Plaintiff may be reluctant to put forth a new bracket because so far, because they had the advantage of throwing out the first anchor, they've been dominating the midpoint. Again, referring to that survey by the Florida Academy of Civil Trial Mediators, question is, who initiates the bracket? Well, the question was, does the mediator initiate the bracket process? 20% of the mediators said they always or frequently initiate a bracketing process. 40% said they rarely, that is the mediator, rarely initiates the process. And 7% of the mediators said they only initiate or suggest the bracketing process when asked. Another thing in the survey was, does the mediator make specific bracket recommendations? 80% said infrequently, rarely, never, or only when asked. I personally think that in the vast majority of cases, the mediator should not be in the business of throwing out the brackets. I think the parties ought to propose the brackets. The mediator can suggest that they move to brackets, but there are real risk to the mediator throwing out a proposed bracket with proposed numbers. The first thing is the mediator may have misread the center of gravity in the room. He or she may have misread where negotiations are going. And so they may throw out a bracket that's counterproductive. If a mediator throws out the bracket, another negative is that the parties may now feel that the mediator is taking sides. So it becomes a perception of neutrality problem. Now, I suppose a mediator can, and I have sometimes done this, put out a fictitious bracket with numbers wholly unrelated to the case to simply educate the negotiators in a process how brackets work. But I think that only in rare cases do the parties ask the mediator to provide a settlement range for them. And even then, I think a mediator has to be very careful. I think if you're a party, you need to be careful asking the mediator to do that for all the reasons I've just given you. It can work, but only if everybody is very savvy and knows what they're doing. Mediators' bracket advantages. Of course, the advantages, it expedites the process. It eliminates people moving along in baby steps. It relieves negotiation fatigue. People, after a lengthy time of exchanging raw numbers, just get tired of doing it. And also, it's move from fictional midpoints to a struggle over more realistic midpoints. Remember that initial bracket of the two anchors. You get a midpoint that is fairly unrealistic. By putting forth brackets and counter brackets and re-bracketing again and again, you slowly began to move toward more realistic midpoints. Most importantly, I think brackets break the cycle of mutual discouragement, and it signals to each party some willingness on the part of the other to settle on some rational basis. Disadvantages: poor timing or unsophisticated usages. Obviously, like any tool, if you misuse it, if you're using a power saw, you can cut off your thumb if you aren't careful. So make sure you've learned enough about it to know how to use it. If it's done too early, it can diminish the psychological effect of your initial anchor. I think that's one reason that plaintiffs are usually reluctant to put out the first anchor. Also, if it's too early, it reduces the effectiveness of the time, effort, investment tool. Remember, a time and investment helps you get cases settled. If you go to bracketing too early, you do reduce the effectiveness of time and effort as an incentive toward settling a case. Failure to misunderstand the signal being sent, midpoint or range. I'll say more about this, but one problem you sometimes have, one party will put out a bracket. Let's say 1,100,000 1,000,000 for plaintiff, 100,000 for the defendant. And the defendant will read that as the plaintiff moving toward a midpoint of $550,000. Well, maybe the plaintiff is not wanting to signal a midpoint. Maybe all they're trying to tell you is we should be negotiating somewhere in a range of between 100 and a million. So always make sure that you have some idea of what the bracket means and what your bracket means when you send it. Another is a failure to incentivize. If I'm a plaintiff and I'm at $100,000 and you're the defendant and you're at 5,000, and I tell you, well, I'll move to 95,000 if you move to 400,000. Well, what have I done? I've offered you a $5,000 move in exchange for a $400,000 move. There is no incentive for me under those circumstances to consider your bracket. So that's a mistake that can easily be made. All right, creating the new brackets, some tips and some caveats. One we just talked about, you must incentivize the opposing party. Another is, do you have room to offer a bracket? If you're only $5,000 apart, brackets become much less meaningful. Make sure you can live with some number reasonably near the midpoint of your bracket. That is critical. No matter what the other party tells you, and you will usually hear, well, we're not really sending you a midpoint. We're just telling you this is a range we ought to be talking in. And you can send that message yourself. But I can tell you that people are looking at the midpoints. So you need to make very sure when you send a bracket that you can settle for some number reasonably near that midpoint. Now, plaintiffs, usually the skillful plaintiff negotiators, will send a bracket that gives a midpoint that is higher than what they're really willing to settle for. Defendants will generally send a bracket that flashes a midpoint that's generally lower than what they really want to settle for. So you know, I don't know that you want to, with your bracket, send the exact number you're willing to settle at, but you need to understand when you send a bracket that the other party's looking at the midpoint, and at the end of the day, you're probably going to be pressed pretty hard to settle somewhere near that, because conditional proposals do create assumptions on the part of the parties. And remember, you can't unring the bell. So we've already talked about building some deception into your midpoint. Okay, brackets and perspective. On the surface level, brackets propose a range for negotiation. This is really what we were just talking about. But on a deeper level, they're really a struggle for a favorable midpoint. And later, through an example, I'll try to show you how that struggle for midpoints plays out. It's always important to understand whether your negotiating opposite is utilizing a bracket to flash a midpoint or to flash a range. And are they consistent throughout the process? Reading bracketing proposals, trading brackets is sort of a dance. How reliable is your opponent? What does their midpoint signal? Beware of regressions of the midpoints, and watch the midpoint of the midpoints. I'm going to say more about that in a minute, so I'm not going to spend a lot of time here on it. But how do you calculate midpoints? If nothing else, jot this down, because I find that most people don't know how to do it. To get the midpoint of a bracket, let's say 100,000 versus 200,000, you add the two numbers together and divide by 2. So if you add the plaintiff's 200,000, defendant's 100,000, you get 300, divide by 2, the midpoint's 150. At some point in time, you're going to see that's the midpoint of the midpoints that's more important than that. You calculate that the same way. You add the two midpoints and divide by 2. Framing the bracket. It's critical when you put out a bracket to know whose turn it is to go next if the party accepts your bracket. And there are numbers of ways of doing it. I'm going to skip the first two from the mediator. Mediators usually are pretty careful to make it clear, but let's look down at the parties. Let's say we here, and the first one is you. We would move to X if we knew you'd respond with Y. Suppose, let's put in numbers. We would move to 10,000 if we knew you'd respond with 50,000. What if the party that you've offered that to says yes? Who goes next? The party who proposes it would go next. Because if I say, I'll move to 10 if you move to 50, then you say yes to that, then you've moved to 50, I've moved to 10, and it's my turn again. The opposite of that, if you move to X, we will respond with Y. That flips it. If they move to X, you respond, and then it's their turn again. Another alternative to swapping outright brackets is to say, we suggest that a more appropriate bargaining range is X and Y. That's another way of offering a bracket. responding to a bracket. You've just received a bracket. And here I could spend at least 2 hours covering all the various ways you could respond, but I'm going to hit the highlights and then let you experiment in your leisure time. But one, you can accept the bracket. Other, you can accept one leg of the bracket, but counter to the other leg. Or you can counter to both legs with a totally new bracket. That's probably what you see most often. Or you can reject bracketing altogether and return to the exchange of raw numbers. Or you can end the negotiations entirely. Now, it gets more interesting because in creating the new bracket, you've got a lot of options available to you. You can move the top number only. You can move the bottom number only when you propose your new bracket. You can move both the top and the bottom number by the same value, which would leave the midpoint unchanged. You can move the top and bottom by different values. You can move the top and bottom numbers in the same direction, that is both up or down. Time doesn't permit us to go through all those permutations today, but I suggest to you that you sit down and play a game with yourself and just experiment with some brackets. Just do remember, though, you want to always know what your bracket means and know what the other guy's bracket means. Now, here comes the fun part. This is a very crude example. I hope that this doesn't occur in anybody's real case, and you'll see why. So let's assume, for purposes of this negotiation, that the defendant's goal is to settle for $300,000. Let's assume that the plaintiff's goal is to settle for something above $500,000. The plaintiff has begun by throwing out a $1 million anchor. Defendant responds by throwing out a $100,000 anchor. As we'll talk about that more in a minute, defendant's made his first mistake here. Plaintiff then goes, we're still at the raw number stage now, moves down 50,000 to 950. Defendant, realizing all of a sudden, hey, I'm moving too fast, moves to 110. Plaintiff moves down to 925. Defendant moves to 115. Plaintiff moves to 900. Defendant moves to 120. Plaintiff ends at 895. So what do we have at this point in time? Both parties are being discouraged. And you notice they're moving in ever smaller numbers. Defendant has found themselves in the pickle that, no matter what they do, the numbers are being skewed more to the plaintiff's side. So the defendant in this case decides, well, heck, I'll offer a bracket. So they say to the plaintiff, we would go to 200,000 with this move. Remember, it's the defendant's turn now. We would go to 200,000 with this move if we knew you would respond at 650. Now, if the plaintiff said yes to that, of course, then it would be the defendant's turn to move again. And the midpoint of the bracket that's been sent by the defendant is $425,000. Now, we've learned a lot here. Both parties have learned a lot here. The plaintiff has learned that the defendant will go at least to 200,000 and maybe even go to the midpoint between 200 and 650, which would be 4 1/4. So a smart plaintiff's attorney here is going to say, well, gosh, the defendant's probably committed to somewhere between 200 and 425. Of course, you realize the problem because we told you the defendant's goal was 300. Defendant's first bracket is really too high. He is increasing his predicament. Then, in response to that bracket, the plaintiff says, no, I don't like your bracket, but we'll go to 800,000 if you respond at 500,000. And if the defendant said yes to that, then it would be the plaintiff's turn again. The midpoint of plaintiff's bracket is $650,000. Now the defendant has learned some valuable information. He or she now knows that the plaintiff will go to at least to $650,000. I'm sorry, at least to 800 and maybe to 650. Then, if what the first thing both of them ought to do, and a smart mediator is always doing it, is add the 425 to the 650 and divide by 2. That gives you a mid-range of 537,500. That's the midpoint of the midpoints. So a mediator would probably scratch his or her head and say, well, maybe that's where the negotiations are headed. But you can see that the defendant here is still way above where they may be headed. So the defendant throws a counter bracket. They say, we don't like your 800, your 500, but we would go to 250,000 if we knew you'd respond at 650. Of course, if the plaintiff says yes, it would be the defendant's turn again. The midpoint there is $450,000. Now, of course, this tells the plaintiff something. This tells the plaintiff that, gosh, the defendant's willing to go at least to 250,000, maybe even 450. Defense counsel here has made another mistake. Look at the midpoint of the 200,650 that he sent was 425,000. The midpoint of the 250,650 is 450. Defendant is not gaining ground. He's losing ground. That is a retrograde movement on his or her part. So, but in any event, the plaintiff responds by saying, well, and notice here that the plaintiff changes the order a little bit. Plaintiff says, well, if Mr. Defendant, if you go to 400,000, we'll respond at 750,000. Well, of course, if the defendant said yes to that, it would be plaintiff's turn again. But the midpoint of that is 575,000. Defendant responds with a bracket that says, if we go to 300,000, if you'll respond at 675. The midpoint there is 487.5. Defendant is losing ground again. Now, there is an error in your diagram there. That 487.5 is the wrong number. That number should be 531,250. If you add the 487.5 and the 575 and divide by 2, that gives you 531,250. So you can see that not only is the midpoint continuing to go up, but the midpoint of the midpoint is beginning to go up. You note the struggle of the midpoints here. In this case, it wasn't much of a struggle because the defendant was misusing it. The one thing we can deduce from this is that the plaintiff probably wants to settle above the midpoints that they're sending. For instance, if you look at the last one, the plaintiff probably would like to settle above the 575,000. remember, they're building some deception into their midpoint if they know what they're doing. Defendant certainly wants to settle before the 487,500. It's just they've left themselves where their midpoint and their goal is so distinctly disparate that they're going to have trouble for the rest of the negotiation. The most important thing to look at is always the midpoint of the midpoints. And let's go back a minute to the 200 and the 650. That tells us at least four things. That's the first bracket that's put on the table. It tells us that the defendant is offering to move $80,000 in exchange for a $245,000 move by the plaintiff. It suggests a more workable negotiation range than the 128.95. It signals an implicit midpoint of 425, and it interjects a little hope that maybe things aren't bogged down. So that's sort of the signal value in decoding. I wish we had a lot more time to discuss bracketing because it's a fascinating subject. If you really want to master it, there's some good books out there. I strongly suggest, or articles. If you'll simply Google bracketing, you'll find a lot of articles written by knowledgeable people. Humpty Dumpty, and if you take 300, if you take 1 from 365, what remains? Alice 364, of course. Humpty Dumpty looked doubtful. I'd rather see that done on paper. This is where you can do yourself and your client a big favor. Do the math. Each party should be calculating the net result of a settlement and the net result of a trial and what the difference is between the two. Defendant should calculate the plaintiff's net early because that provides insight in what it may take to settle the case. Each party should calculate his or own net sometime in the negotiation. Here's an example. This is the plaintiff's. The plaintiff is offered $100,000 in settlement. They know that they're going to have to pay a $40,000 attorney's fee. There's a $10,000 medical lien. There's $5,000 in costs. They net $45,000. Well, let's see what happens if they go to trial. Let's say their attorney agrees that a reasonable verdict's around $150,000. If that's so, and they get that verdict, then they've got $60,000 in attorney's fees. They've got $10,000 in lien. They've got $20,000 in costs because now they've had the cost of going through a trial. So they net $60,000. They've had to risk a zero verdict to gain $10,000, to gain $15,000. So what does a trial do for them? Gives them maybe an extra $15,000 and maybe a goose egg. Defendant, same scenario. Defendant can pay $100,000. They've already spent $20,000 in attorney's fees. They've already incurred $5,000 in cost. So they're out of pocket $125,000. But if they go to trial, and let's say they hold the verdict to $50,000, now they've built up $40,000 in attorney's fees because they have to pay their attorney, assuming the attorney's on an hourly basis, to go to trial. They now have increased cost of trial. So the net is $110,000. They've had to risk a high, maybe runaway verdict against them to save $15,000. So this is what I like to call the in-game risk analysis that the parties ought to be doing. Then the end game. What do you do when you get down to one party tells you, this is my best number? Well, I know what I do as a mediator. I look them in the eye and I say, look, I can clothe that number. Let's say their number is 100,000. I can clothe that number with as much or as little finality as you want me to. But I don't want to nail your feet to the floor unless you make me. I want to know exactly how final they want me to make that number when I go into the other room. When you're negotiating, you may not have a mediator in the mix. You may be negotiating face to face. You have to consider how final you want to make your number. There's a real temptation to say, this is 100,000, take it or leave it. Well, first off, you bring psychological factors into play that increase their chances of their losing it, because no one likes to lose face. You also eliminate the possibility that they might offer you 105,000. Then what do you do? One way that I think you can signal an end is send that number in by the mediator or give that number to the opposing party. When the opposing party counters, simply repeat your last number. I'm sorry, but 100,000 is the number. If you are the recipient of that message and you're trying to entice the other party to make one more move, you probably are going to have to get pretty close to that number to make them, to tempt them to make the move. I call it getting the carrot close enough to the rabbit to make the rabbit think he can get it. Offers to split the difference. There are two distinct schools of thought on this. You'll have skilled negotiators tell you never to offer the split the difference. It's a sucker play, because then they'll want to split the split with you. You'll have other negotiators who will tell you, certainly you can offer to split the difference. Just tell them, hey, look, you're not looking to split it again. And I sort of lean toward that latter. I think the message you send with it's important. Maybe you can make collateral concessions. Maybe you can say, well, this is the best number that we can do, but what if we offer you part of X sales territory, or maybe we can offer you confidentiality. Those are the types of things. The silver bullet, you've all heard of. The silver bullet is when the mediator puts two numbers on two separate pieces of paper, the same number, and asks the party to say yes or no. That can be effective, but I caution you, you need to make sure if there are any non-monetary components to the settlement agreement that they are agreed upon, and that the only thing left to decide on is the number. Otherwise, you're going to get a conditional response. In fact, I would suggest to any mediator doing this that you actually write those non-monetary terms that have been agreed upon on the pieces of paper, so that everyone understands this is the last thing. You're still going to get the occasional nibbler who wants to extract that one last ounce of blood. I like to call them the Russian-style negotiator. But the parties will simply have to learn to deal with that. That's another interesting subject if you ever want to do some reading. So having said all that, I'm going to sort of bring the session to an end. I'm not going to be taking questions, but please do send me an email if you have anything that you think I can answer for you. I'll be happy to do it. You've got my email there on the title page. Kathy is going to be taking over in a minute and giving you the CLE number for purposes of the course. I really enjoyed talking with you today. I wish I could have seen you face to face. It's always hard talking to a screen, but I really hope I've given you just a few nuggets that you can use. For any of you interested in sharpening your negotiation skills in general, I'm going to recommend a couple of books to you. They're not new books, but I think they're among the best. One is a book by Bob Wolf called Friendly Persuasion. I still regard it as one of the best things ever written on negotiation. Another fun, tongue-in-cheek book is You Can Negotiate Anything by Herbert Cohen. He has a sequel to that that's lengthier and equally tongue-in-cheek called Negotiate This by Caring, but not that much. So having said all that, I bid you good day, and I'm going to turn it over to Kathy.
Well, thank you, Howard. 1 second, here we are. If you're a Florida attorney, please jot down the Florida Bar course number so that you can post your CLE credit online. It is 2101522, N as in Nancy. One more time, that's 2101522, N as in Nancy. We're building our webinar schedule for the remainder of 2021, so please watch your inbox for news about our future programs, beginning with preparing for and mediating employment cases on April 27th. So you'll see the contact information there. If you have any questions, for content questions, please email Howard at hmarsee@uww-adr.com or email me if you have questions about the course number, webinar recording, or anything else technical. Thank you very much for joining us today. Hope you have a great one. Thanks again, Howard.
Thank you.